Okay, good evening, everybody. This is a regular scheduled meeting of the Town of Darien Zoning Board of Appeals. It is Wednesday, October 19th, 2022. It's currently 7:39 p.m. Before I get started with the applications tonight, there's some housekeeping business to take care of. There are a couple of there's a postponement calendar number 12, 2022, Matthew Albertelli at 20 Chester Road. That application is postponed till November the 16th. If you're here for that application, we'll see you in November. Also continued this evening is calendar number 15, 2022, the application of David and Jennifer Brown for the property at 15 Revere Road. That application is also continued to November the 16th. If you're here for that application, we'll see you in November. Calendar number 16, 2022. The application of Wilder Gleason on behalf of William Hausberg for the property known as 8 Pratt Island is now reopened and also continued to October the 26th. So if you're here for Hausberg at 8 Pratt Island, we'll see you October the 26th. Any questions, comments, or concerns about those postponement, continuations? Thank you. Okay, starting with tonight's application, this is calendar number 11, 2022, the application of Peter Crawford and the Sugar Bowl, doing business as the club for the property known as 1031 Boston Post Road. And that is Mr. Crawford. Mr. Crawford, are you with us?
Yes, sir.
Awesome. Thank you very much. We have your application and the materials you've now provided us. The board greatly appreciates those submittals. Thank you very much. Why don't you take us through it?
So there were some questions on, some easements that we would give to the town to help with conformity. So we decided to give 10 seats up to try to reduce impact on the town. I'm backpedaling here. Let's see. So did you guys go through it at all, or?
Sure did, but we'd like, for the record, for you to explain to us. I think there might have been some concerns about the number of seats, which I believe you just addressed. It's not an easement that you're giving the town. You're sort of decreasing a non-conformity to make it a little more acceptable, maybe by the board. But why don't you take us through the history a little bit? Tell us what you're going to do with the property. Tell us you're taking the number of seats from what to what.
Thanks, Jeff. So what I want to do is bring my expertise, my years of training in very, very nice restaurants. I want to bring that to Darien. And so I've worked in some very nice places, and I've got a lot of experience. And I think I can provide Darien with a very nice option for dinner that would require accompanying drinks for a food and wine pairing. My 30 years in top tier restaurants has really taught me that food and certain wines go together. So I want to bring something to Darien that is a classic American bistro, that is based on classic American cuisine, that is very gastronomic. Um, so
Okay, Peter, Peter,
the atmosphere.
we understand what you'd like to do with the property.
This
But
is all gonna this is all gonna explain the layout and then the functionality. Really
no,
quickly.
we get that, but let's move on to the more substantive issues. What will your hours be? What will the number of seats be? We know that you've applied for a liquor license, so that's going to include hard alcohol. So just briefly talk to us about what I just described, the
Yeah,
hours,
but
the increase.
Jeff, if I can, it might be good to compare. So it's an operating business now, but the issue is to how he might be intensifying the use of the business. So comparing the hours of operation currently to what's proposed to do, comparing the number of seats now to what's proposed. And before he says that, let me just say for the record that although I was not present at the first hearing, um, whenever it was last month, I have reviewed the recording of that hearing. So now I am up to speed on this application and am able to sit here tonight with the rest of the panel. Um,
So brass tacks, starting tomorrow, we're gonna be doing 5:30 to 9 Thursday, Friday, and Saturday nights. And we have 70 seats. And so we're going to start a dinner service. Um, Currently, we serve about 700 meals a day, or a week rather, and that's for breakfast and lunch, 7 a.m. to 12 p.m. Peak day being about 200 meals. Um, Dinner is much more slower paced. So we expect a peak day for dinner to be about 70 meals, seeing how people sit for longer, and we have reduced seats. So currently we have 60 seats and zero parking, and we seek to transition to 60 seats from 70 seats, and we want to use the back space for staff parking.
so Peter, if I can, this is a kind of intensification. So the question really is parking. When is you said your peak day is 200. Is that during the weekend? I assume that's Saturday or Sunday?
Saturday.
Saturday. So um, you seek to utilize the parking that's adjacent or that's in the general area, and the intensification of the use is during non-business hours. Is that correct? Or non-normal business hours?
That's correct. There's a lot less businesses opened after 5 p.m. It kind of clears out,
Right.
especially upstairs. The upstairs tenants all leave. The Brook Street office building, everyone leaves. Um, and there's just less foot traffic with all the retail stores closed.
So it's really, Jeff, it's really a parking issue, isn't it? That's the way I kind of listened to and read the application. It's whether there's
Yes,
enough
that's what
parking in the general area for the
that's what
intensified use, which is during non-business hours.
yeah, that's the variance he needs a parking variance in order to get a liquor license. Yes, sir.
Okay.
Okay.
Um, yeah.
All right, Peter, is there anything else you'd like to add before I go to the rest of the board for any questions, comments?
Um, I think everything has been addressed, hopefully. Yeah, I think I I think I'm good. If anyone has any questions, I'd be happy to answer them.
All right, thank you very much. Barb?
Yeah, hi, Peter. I read your bio and I've known you for a while in terms of what you provide to the town. And I love what you give back. And I think you would make a very successful food establishment. My concern is really just around intensity of use. Talk to me about the bar situation. I read in the notes that you will not be having a stand-up bar. So you would only be serving alcoholic beverages to the tables. What happens to the existing breakfast bar? Talk about any remodeling that you would be doing and how that would change the seating capacity.
So we're going to reduce 10 seats. Remodeling, the breakfast bar has not been really going to be changed. Now that you mention it, I see how, people might view it as a place to sit down and drink. We're not gonna do that. We should probably just like say in there, like, no, we don't serve alcohol without drinks, or beer without drinks. I'd be happy to put that in there.
You mean
But
without food? That alcohol is
yeah,
served only with food?
that's correct.
Okay.
Because I could see how people could sit down and then just be served, because we don't really want to be a bar. We're trying to be a American bistro. So to answer your question, right now, currently the seating is not going to change on the breakfast bar, but we are going to say, no, we're not going to serve drinks without food.
Well, I also think the way the bar is set up now, it discourages someone to sit out. It's not a typical bar like a 1020 or a Goose. So you can't stand at it. So will you be expanding the hours beyond the Thursday to Saturday, 5:30 to 9 in time? Are you looking to add Tuesday, Wednesday, and Sunday, for example?
Yes, that's in the future. I'm trying to build the base. You actually need clients to consume the food to keep it fresh and peak. It sounds ridiculous, but without a good client base, you can't serve good food. It's kind of a horrible scenario.
Will you be
So
doing a delivery business out of there? I know that Uber Eats is very popular. Will you set up any kind of delivery or pickup station as part of the parking requirements?
there's some, yeah, there's we are offering Uber Eats currently.
Is there a designated Uber space now for it? I don't know of anything.
There isn't. No, I don't think there's for anybody downtown.
Okay. Okay, I'll stop asking questions. Somebody else can go.
Thank you. Dan, questions, comments?
Yeah, just a quick question. Peter, as you can understand, one of the key requirements for us to make a decision is to understand the nature of hardship. Can you please explain or define what the hardship is in your case that we
Yes.
can evaluate?
Yes, the hardship is that we are a restaurant that has been operating for 80 plus years, and there's never been any designated parking. So we've been operating as a non-conforming business with difficulty in parking. So we are looking for a leniency in difficulty of parking in order to apply for a liquor license.
So non-conformity put an handicap on you in terms of the parking, and that's where you are looking for some relaxation.
That's right.
Okay. Thank you, Peter.
Yeah.
And part and parcel, I think, Dan, he's offering to reduce the number of seats. So it's his take on reducing the intensity of the property and trying to make an effort to make it the minimum adjustment necessary. Matt?
No issues for me. Thanks.
Okay. Gary?
I've asked my questions. Thanks.
Okay. Anybody in the public would like to be heard on this? No, silence is golden. Okay, this application is closed. Thank you very much.
Thank you. I look forward to serving you.
Thank you. Okay, we're going to move on to calendar number 10, 2022, the application of Jeffrey Merman on behalf of Cindy Hardy for the property known as 26 Peach Hill Road. This is a very complicated appeal matter that involves two separate issues. One being, and in no particular order, by the way, but one being the timeliness of the appeal filed on behalf of the Hardys. The other being the nature of that appeal is such that it is described as appealing the issuance of a building permit, excuse me, as issued by the building department. And that's a venue jurisdiction issue. So there are two matters at hand here, and I'm going to deal with one at a time. The first issue I'd like to deal with is the timeliness of the appeal being filed. So, Mr. Merman, I, as well as I am assured the rest of the board members, have read through the plethora of items submitted for this application. Yeah. So I can say that we're fairly well versed, but I would also ask you to keep your comments to the point, narrow in scope, and we don't want this to go on all night because we're going to handle one matter at a time. So let's first find out what the board's feelings are with regard to the timeliness of the filing. Mr. Merman, the floor is yours.
Thank you, Mr. Chairman. Thank you, members of the board, for having us this evening. I'll be brief on each of these issues because, as I understand it from Mr. Williams, you have received our answers to the questions submitted by staff that deal with these issues. With respect to the timeliness, notwithstanding that the building permit was published in the Stamford Advocate, Mrs. Hardy did not have any notice of the issuance of the building permit until sometime later. And in fact, it wasn't until after Attorney Gleason informed my colleague, Tim Hollister, that the permit had been issued. The law provides in section 8-7 that the appeal period commences, quote, upon actual or constructive notice of such order, requirement, or decision. And constructive notice cannot be construed to be the issuance of the notice in the Stamford Advocate. If that were the case, then everybody in town would have to, if they thought that there might be something going on in their neighborhood, they'd have to be looking at the Stamford Advocate on a daily basis. Mrs. Hardy had no reason to believe that this building permit would be issued. Therefore, she had no reason to look into the Stamford Advocate or any other place to determine if the permit had been issued. What she did was, upon learning of the building permit, she submitted her appeal within the statutory 30-day period. In fact, it was just 10 days later. And in our view, that's all that is required. She timely appealed the issuance of the permit upon actual notice, and that's what we believe both the statute requires as interpreted by the case law that we've provided to you.
Okay. All right. So that is.
I'm sorry, can you repeat that citation again on where it says actual constructive? Where is that citation?
That I'm looking at, I cited it in my papers from the other day. It's the Wiltshire versus Zoning Board of Appeals of the Town of New Milford case, 106 Con App 1 at 2008.
So you were
Um,
reading an opinion, not the statute. What does the
Well,
statute say?
it's the opinion that says, and I'll just read it. 8-7 provides that the appeal period commences upon actual or constructive notice of such order, requirement, or decision, quoting from the statute.
I'm gonna give Gary a moment so he can further opine on this.
No, I'm not opining on it.
I don't mean to say
It's not my
opine,
job.
I'm saying make comment to it.
And what is the exact language of the statute? And you say it's in your papers, and I believe you, but I read them, but I didn't earmark everything, so.
Hang on 1 second, please.
I thought the statute said, or 30 days included, or 30 days from publication.
It does.
Doesn't the
But it
statute
requires,
say within 30 days of receipt of order, and there's no
Mhm.
obligation to provide the order, or the receipt of the order of the requirement, or publication of the decision of the determination?
right, but as the,
That's the statute, and you're
Right.
saying that the case that you're citing interprets that to mean actual or constructive notice?
right, mhm.
And do you have sites that say publication in the local newspaper is not considered constructive notice?
I do not have that, although I did cite, again in my papers, a definition of constructive notice. Is information or knowledge of a fact imputed by law to a person, although she could have discovered the fact by proper diligence. And in this case,
Could have discovered the fact by proper diligence.
I'm
Okay.
sorry?
Could have discovered the fact by proper diligence.
Right,
The
and in this,
problem here is that of this panel, there's one attorney on it, if I'm kind of scanning it, and that's me, and I'm not a land use lawyer. So, unless we're really briefing and we have access to all, I mean, you're citing from one case, and I'm sure Mr. Gleason's going to tell us that there are other cases that find differently. So we're in a very difficult position asking a lay board to evaluate case law.
right.
Very
I'm
difficult.
not disputing that. It's not an issue which comes up every day, certainly. But in this case, given that Mrs. Hardy had no reason to believe that the building permit would be issued, and she acted appropriately upon learning of it, I think you are well within your jurisdiction, if you will, to consider this timely, given what I believe the actual case law to be, and how unfair it would be to deprive her of this opportunity, given that since she had no reason to believe that the permit would be issued, she had no reason to consider
Can you,
that it would be published in the Advocate.
and I apologize if this is covered, but would this project would not have required any type of variance, right? So she never would have been the landowner, adjacent landowner would never have been required to actually provide her notice, like in a variance application where you actually have to give and get evidence of having provided notice.
Correct.
That wouldn't have happened in this case.
Right. And it did not happen in this case.
Right. It wasn't necessary.
Right.
Mr. Merman, I have in front of me all the materials that you provided. Is there
Sure.
an exhibit I can reference where you cite that opinion?
Not in those materials because that issue did not come up at the time of the filing of the appeal. It was raised by staff, I think it was last Thursday or Friday. I mean, I'm happy to submit the opinion to the board if it wishes.
Well, it's
I'll
kind of
let
hard
the
for us
chair
to
decide.
decide. I'm with Barb. It's kind of hard for us to decide the strength of an opinion. I don't know whether it's and then we'd have to engage town council to determine whether that opinion is still good law, or whether there's anything higher up. I'm sure you'll say it is.
It is good law, and I invite you to engage town council in this
Thank you.
endeavor. And I think on the next issue, town council should be engaged as well.
It was the chair's intent to continue this hearing so we could confer with town council anyhow, but I do want to get the facts
So
that
Jeff,
we know.
Jeff, if I may, it does seem like the narrow issue here is whether a neighbor, whether the clock starts on a neighbor's opportunity to appeal the day something is published in a local newspaper, or does the clock start when she has actual or constructive notice, which may have come much later than the publication. So
Right.
that's maybe we hear from on that one issue, maybe we hear from the other side. I see why they're raising the hand. But then I agree with you, Jeff. It's going to be very hard, even for me, without further input from town council, to decide that narrow issue.
Yeah, I agree, and that was my plan. Was a further conference with town council, which I have for the last 2 days. In any event, before I go to Mr. Gleason, does anybody have any further comment or question for Mr. Merman? Then I'm gonna go to Mr. Gleason and have him respond to Mr. Merman's comments.
Could I share my screen, please?
Yeah,
Your audio is bad, Wilder.
Yeah,
Is it bad?
You're in a tin
Yes.
can.
Oh man, this happened last night, and I thought we were okay. You know what? I can call in, which I will do, and I'll cut off my speaker. That probably will give us a better shot at this. Oh.
Please enter your access code followed by the pound or hash sign.
Wilder, I think you're in. Oh, maybe not. No.
Jeff, can you grant him permission to share his screen, or does that need to come from channel 79?
Channel 79.
Yep,
I'm gonna move to the center.
Chris, thanks.
There he goes.
No. No, we can't hear you, Wilder.
He has to unmute that calling on that.
I can unmute. I think I can do that. No, I can't.
Give me 1 second.
Is that better?
You just unmuted for that one. You need to unmute the caller 4, which is essentially you, the one you just logged into right now, which is on your phone.
Unmute caller 4. Whoever has control needs to unmute caller 4.
Yep, I'm getting onto that.
Okay.
Where's my fucking phone? Casey, can you give me my phone? Ah,
You're not on mute.
oh yeah, I'm well aware.
Oh.
That's even worse.
Well, at least we can find some humor in a tough situation. At least I'm looking for it. Having a hard time finding it.
Jeff, you want to respond to each of these issues one at a time. You want to address the timing issue and then the second issue separately.
Yes, because it counsels.
There we go. I sent in a new request.
Okay, council's opinion of this matter is if the board feels and hence votes that it was not filed in a timely fashion, then there's no point in going on to issue number 2. But we haven't gotten there yet. Let's hear what Mr. Gleason has to say. And
But we're not going to resolve that issue tonight. So do we hear number 2 anyway?
I think we hear from Mr. Gleason and
I
then
know,
we.
but we're not going to resolve it
Right.
tonight without
Right.
town council weighing in.
Good point. Do we ever hear the issue 2? Probably not. We have to get past this one.
I had just excuse him. Try to log back in again to that caller. Gleason,
Wilder, yeah. Okay, hang on, Chris. Wilder, if you reboot.
I think I just got disconnected.
Yeah, so I wanted you to
I'm gonna
reconnect.
call back in.
Why don't we just use his audio? Tin can or not?
Okay. Let him try one more time. And yes, Gary, I understand, but
So I think we let them get on the record their argument on both points because we're not going to resolve the first one.
well, we'll discuss that. Right now, the town council's plan is we're going to continue this thing and have a discussion about the timing of this issue, and we'll vote on that when it gets reopened. And if in fact at that point, after consultation with town council, the board votes that they did not, then there's no point in going to 2. I'm not going to 2 until we resolve 1. And I don't care if we resolve 1 tonight, November 16th or December 14th. Doesn't matter to me.
Yep.
Right now, I'm within my time limits with regard to continuing. I have plenty of time to continue the matter.
I have not, okay. I don't want to activate my speaker, but I wanted to let you know I got cut off. I am now caller 5.
Well, Wilder, what I'm going to do is, because I'm sorry, but I'm not too sure that I can't, the audio is not audible, and therefore that's going to cause a recording problem. So I'm going to ask you to leave the meeting completely. Just hit leave, get off of Zoom or go to meetings, get off of go to meetings, reboot, re-sign in, and I think he just did. There you go. Bingo. Try this again. Not too sure. Where did Patty go? Patty, you can opine on this thing, can't you? Right now, not the case. I'm talking not the application. I'm talking about what happens if I can't hear Wilder. Do I just continue it from there?
Let's see if rebooting brings him on, because
Roger that.
How's this?
Wilder,
Is
give me a
this
test.
okay?
One,
Is
give me a
this
test.
better?
1, 2. Give me a test. 1, 2, 3. 1, 2, 3.
Test, 1, 2, 3, 1, 2, 3.
Not great.
Wilder, this is Fred. What you need to
Yep.
do is you need to log off GoToMeeting altogether and just call in on the number. And hopefully that resolves the issue. For some reason, when
I have, the problem is, I have copies of the statutes and the town codes that I submitted. If you have those, I sent them to you, the codes. If you can put them up on the screen, that would be great. And I'll do it, I'll go call in, okay? So I'll log.
Do we have copies of his presentation?
I
do not.
do not.
I do not have
Jeff, in the
copies
meantime,
of
can you give me the site to that
presentation
case?
either.
I thought we emailed it out today to the ZBA members.
Okay, I have that. That's from Wilder.
Yes, that was emailed out to both Mr. Merman and the ZBA members earlier today. So you should all have it. If you don't have it, I could email it back out to you. This is Jeremy Ginsburg, Director of Land Use.
I have it,
Jeremy,
Jeremy. Thank you.
I don't have it.
I'll shoot it right through to you. It's a PowerPoint from Wilder Gleason. Let me turn off my microphone and.
Yeah, if you could, Jeremy, send it to all of us. That'd be great.
Somebody wanted the citation to the case law that we referred to. That right?
Yeah, can you just say it slowly, please?
Yeah, there are two cases that we had cited. The first being Monroe versus Zoning Board of Appeals of the town of Branford. That's at 261 Connecticut, 263 at pages 273 to 274. And then the second case that I made reference to earlier is Wiltzius, Wiltzius v. Zoning Board of Appeals of the town of New Milford, 16 Con App 1, 2008.
No, you got to do it slowly. Do it again.
Right.
Do me the citations again, not the name.
The first, 261 Connecticut, 263.
I got that one, the second one.
16 Con App 1.
Yep, okay.
That's a appellate court decision.
Yeah, I get it. Yep, thank you.
For some reason, the software is muting all callers coming on to the system. Wilder just came on again as caller number 6. He's muted. There's no way for us as organizers or administrators of the meeting to him. So we're either going to have to hear him with the audio issues that he's experiencing on his computer or find some other alternative here.
The other issue, Jeff, I'm looking over what Jeremy sent earlier. There isn't a PowerPoint. There's just the one letter from DeVesta Civil Engineering.
I have Doug DeVesta's letter. I have that.
That's the only thing that came through to me. I do not have a presentation, Jeremy.
Yeah,
I just tried sending it again. So take a look. I just sent it again about 30 seconds ago.
Well, I mean, what am I, Patty? I guess I can continue it from here. I guess, right? I mean, and start over on this 16th.
I do think that Wilder Gleason does have the right to speak. So if we can't get him on, I will note too, Jeff, that Wayne is on the call. He just doesn't have, he can't get his camera to work, but he is.
Understood. Understood. Yep. Roger that.
Jeremy, I just received the email. Thank you. I have not seen this before, so I appreciate it. I don't think it came through.
Yeah.
Does it make sense for the town council to weigh in and for us to reconvene on the 16th or the 26th if it's the next meeting, and we can explore these issues further?
Well, I'm just receiving this document now. I just received it as well, Barb.
I can't weigh in on this yet. It's too much. It's 14 pages and it cites all kinds of statute. I'm sorry, I apologize, but it would take me a while to digest this.
I
It would
tend
take
to
Gary a
agree.
while to digest this.
I just skimmed, Barb, I skimmed it, and I don't disagree. I mean, I think it really prejudices Wilder to have Wayne talk if we can't hear from Wilder.
I agree. I think unfortunately for technical difficulties, we're going to have to wait and delay this and address the timing issue first and foremost.
Yeah, I have every intention of listening to Wilder. We just can't hear him tonight. So,
But it'd be nice if town council between now and our rehearing, next hearing, submitted a memo to the board, public, not, I don't think attorney-client privilege, that addresses the case law and statutes cited by both parties, because Wilder submitted something in writing. The applicant submitted something in writing and now has provided citations and maybe wants to make that available to Wayne. And it'd be great if town council could provide written guidance to us before the next hearing. I assume neither applicant or, not defendant, but the other side the landowner would object to that.
That's correct.
that is correct. Mr. Merman just said. Wilder, he's giving me the thumbs up. Jeremy, please go ahead. Jeremy, get yourself off mute. There you go.
Jeremy Ginsberg, Director of Land Use. Good evening. I think what I would like to do is the opportunity to also include, for the record, especially if this can be continued, I can get it out to the ZBA fairly soon. It's from Connecticut Practice Series by former Judge Fuller. It's really when you talk about Judge Fuller wrote the book on land use, certainly he covers every topic, even some I never even knew about. But in this case, the topics he covered are very, very, very pertinent to this case. They're right on point, in fact. And so I'd like to submit for the record, and I'll do that especially since it'll be continued, Section 8-6, which is specifically called Reviewing Decisions of the Zoning Enforcement Authority and What Can Be Appealed. And there's a whole nother section, Section 12-6, the Building Inspector, which talks about both issues, the timeliness, what Section 8-7 of the Connecticut General Statutes and 8-6, it's right on point. It couldn't be more obvious from Judge Fuller's documents that he is almost speaking to us here. So I want to make sure the ZBA gets a copy of those sections, because I think it will answer the question simply and succinctly. Thank you.
Okay.
I assume we'll have an opportunity to comment on that.
Yes, you will.
Thank you.
And we're going to make sure that everybody has the opportunity to comment on any submissions to the record, okay? Unfortunately, it just doesn't look like that's possible tonight. And with fingers crossed, we'll be live and together, if you will, in room 206. Now, Woody, are you still with us? We're going to continue this hearing right now. I would prefer to continue it to November 16th. I believe town council said I have that much time. I do not have to do this next week. And I would like to give Jeremy ample time to prepare his submission from Judge Fuller. And I know the board probably agrees with Barbara and I and Gary with respect to reviewing Mr. Gleason's submission as well, which I think is in fact unfair that I just got it literally 4 minutes ago, and yet I've spent several hours going through the other side's opinion. So that's not fair, and I'd like enough time to let everybody review everybody's submissions. Now, before I continue, does any board member have any questions regarding my comments? Okay, this hearing is continued until November the 16th. My apologies to everybody. You know, like I said, we're a little bit rusty on this virtual thing, but hopefully we'll be together in room 206 on November the 16th at 7:30. Now, jeez. Now, okay, this hearing's been continued, so now I'm gonna go to deliberations. Bless you, Mr. Green. I'm gonna go to deliberations, and we're going to start. Well, we only have one application to deliberate. It's the Sugar Bowl, doing business as the club. Barb, I'll start with ladies first, please.
Oh, geez. I mean, this is such a tough one. I love that we have a local operator who's trying to improve the business. I am concerned about intensity of use. So I'm supportive of it if you can eliminate the 10 additional seats, which will reduce the intensity, especially if we're going to go to night 3 nights a week. I don't really want them going to evenings 7 nights a week. I'd really rather keep it to 3 nights a week. You know, I mean, I think the intensity on parking in general, what Genevieve's is doing down there, is just an ongoing issue. I just don't. So for me, I'm going to pass it, but I don't really want to, because I think the parking is a growing issue for our town, and
Yeah, but
intensity of use is increasing.
you can't bring, I don't think it's fair to bring Genevieve's into, because his
Okay.
application was reviewed by P&Z and determined that the parking that he's providing is sufficient for all of his use.
Yeah.
So I don't think it's fair to impose a burden on the Sugar Bowl or the club because of the analysis that we are going to have to assume was done appropriately by P&Z, notwithstanding what they allowed in the Heights. I think my view is that 3 nights or 7 nights is immaterial because his increased intensification is not during the normal business hours. Trying to go to 10:20 for lunch is really difficult, but going to 10:20 for dinner is much different because of
All
what's
right.
available. The train station is available. The train station parking lots are available at dinner time. I think if he were expanding the number of seats during peak, daytime parking problems, I agree with you, but expanding it during the evenings, whether it's 3 evenings or 7 evenings, I think we should allow it.
And the bar issue that doesn't concern you?
Well, I think it's. I mean, I think the regs go to seating, and I think he kind of answered your bar issue. I wouldn't require him to say no one can stand and have a drink. I don't think that's necessary. But I think we're all parking is hard in town, but I think during the evenings it's better.
I'm going to say yes to it, but it's not very clean for me.
Yeah, well, we won't really. I agree with you that we won't really know the impact until he's open, and that's
Chick-fil-A, Gary. Chick-fil-A.
Oh, ouch.
I don't know what that means. Do we have Chick-fil-A? We don't have Chick-fil-A.
Well, never mind.
The line.
Dan, thank you, Gary. Thank you, Barb. Dan.
Yeah, I'm in support of his application. I think he heard us from from last time. He reduced the number of seating from 70 to 60. I also agree with Gary that the timing, the intensity of the parking during his peak hours would be would not matter as much because it's in evening, mostly on the weekends. And again, it's a pre-existing condition for him as a non-conforming parking issue. So on those basis, I'm in support of his application.
All right, thank you, Dan. Matt?
I agree with everything you guys are saying. I've been to the Sugar Bowl, like I'm sure all of you guys have, 100 times. Every single time I parked in the Muni parking lot to the northeast of Sugar Bowl, and that's a totally reasonable place to park. So for me, that's not an issue. So yes, I'm supportive of it.
All right. Woody, I'm gonna get to you in just a second. And because I'm sure Woody's gonna want to ask about stipulations. By the way, the item K, and the very last paragraph of item K, I think is very confusing. I think they're either typos or I'm not all too sure what, but it doesn't make much sense. But maybe I'm just misreading it. But with that said, is everybody okay that they're open until 12 a.m. serving dinner? I'm not sure I care.
I don't think that's in our area,
Yeah.
is it?
Yeah.
Are you saying that we can't stipulate to certain hours? Is that what you're saying?
But what? Because there's a lot of people parking at 12 a.m.
Well, that's true, I guess.
Yeah, I think we can only speak to parking, and that's even less of an issue at 12 a.m. If he wants those hours of operation, have at it.
I agree.
Okay. All right. And I'm good. I'm fine.
So are we going
Woody?
with the reduction in seats? Or are we going to take his proposal?
Yes, we are going to stipulate. We are going to stipulate
Yes.
60 maximum
I do
number of
think
seats.
that brings it into modern time. Like, we're giving him something, so we're getting something. I kind of like that trade-off. But I'm good with it.
Yeah, well, he's making an attempt to lessen the intensity as far as I'm concerned. Some might not agree with me, and that's okay. That's perfectly fine.
And Jeff, I think we are assuming that he has the liquor license, which meets all the state regulatory requirements.
Right. Agreed, because he needs this variance in order to get the liquor license.
Yeah.
Okay.
So I want to ask Gary, I guess, does the variance then specify a certain number of spaces? Or we're just saying based on the intensity of use, we feel there is adequate parking?
We can stipulate that we're giving the parking variance, based upon his, acknowledgement or whatever, the restriction that there's 60 dining seats, not 70 or whatever.
Yeah, it's a normal stipulation.
Yeah.
Okay.
I don't know. That it's based upon 60 dining seats. Yeah. Because parking is tied to that.
Yes.
Okay.
Are we going to do a motion?
If
You want to do a
if
motion for
there's
approval?
if there are no other questions or comments, then I'll ask for a motion.
I'll move to approve the application with the stipulation that the club is restricted to 60 dining seats. The club or Sugar Bowl or whatever.
I'll second the motion.
All in favor? Okay, that's 5-0. All right. I'm gonna go on to other business right now, and I'm only gonna ask for the approval minutes for the meeting on July the 20th. That was me, Kevin, Matt, Dan, and Barb. I only have 3 of you here, but that's okay because I only need 3 for the approval of minutes. Can I have a motion to approve the minutes of July 20th?
Motion.
Thank you. Do I have a second?
Great. Second.
Great, that's good. Minutes of July the 2nd have been approved. Okay, with that, may I have a motion to adjourn?
Motion to adjourn.
Do I have a second?
I'll second.
All in favor? Thanks, everybody. I apologize for all the difficulties tonight. I hope that we get town hall reopened to be live again next week. Okay. So
And
have
Jeff,
a good evening.
Jeff, before we depart, are we going to have these meetings as needed? Are we back to once a month?
No, the maximum number of meetings, I saw your text, I told you that I would call you after the meeting, but since you brought it up.
Sorry, I didn't know if it was about that.
Let me call you afterwards, okay?
Okay.
So thank you very much. I believe I adjourned this meeting successfully. So with that, my apologies once again. Enjoy the rest of your evening and I'll see you next week.
See you, Jeff. Thank you.